When it comes to bedtime stories, are you allowed to legally read those on YouTube, on live streams, and public performances on your other social media platforms? Or is this something that is a copyright infringement? We have a full mini series of videos with our lawyer breaking down what you need to know about this. And this was a question that came up as a reaction to those videos where we break down the legal side of this. So let's get into it and talk with everybody's favorite IP entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
Tony, we've been talking a lot about whether or not we can read books on YouTube, on social media, in live streams, or in public performances. We have a ton of episodes covering this, but we still have more follow-up questions. This time, people want to know whether or not they're allowed to read bedtime stories online.
So the answer is going to be no, with the caveat, though, that we're talking about bedtime stories that are still protected under copyright. We've talked about it in previous videos on Cam's channel. You can check them all out on the playlist. But the bottom line is, if something is still protected under copyright, meaning that there's still some type of active copyright term associated with that work, there is no world where reading it in a public forum, let alone social media, which is surely a public forum space, is something that is allowed in any way, shape, or form. So let's kind of break down the whole nuts and bolts of this. Picture books, bedtime story books, full-length novels, whatever you talk about, those are all different types of works of authorship that are covered under copyright law. Copyright Act of 1976 has clearly laid out that a copyright is an original work of authorship fixed in a tangible medium of expression. We can make no argument that books, again, whether they're specific to bedtime books or picture books or anything else, those are all worthy of copyright protection. Now, since we're talking specifically about bedtime stories, the moment that bedtime story is written as a book or as a little, a vignette or whatever, and is part of a larger anthology of bedtime stories, the moment that work is created, there are rights that immediately vest with that copyright owner. They're all laid out in 17 U.S.C. 106. And multiple rights here apply: the reproduction right, the public performance right, and even the public display right, especially if you're going to be in the space of not only reading the bedtime book, but even showing pictures if they're complemented with that specific story. So all that to say, when author A writes that bedtime story, those are their rights. They have the right to create reproductions of that specific work. They have the right to publicly perform it, meaning that they, the author, can go to a Barnes & Noble and read it out loud. They can go on their own YouTube or TikTok account and read it for an audience. It becomes a totally different narrative when you, not author A, but just random Joe Schmo or Susie Q, decides to read the book in a public forum like TikTok, like Instagram, like YouTube. Those are platforms where surely there's a public audience that is drawn, and you would be violating the public performance right and quite possibly even the public display right if you were showing and reading those books out loud in front of a pretty large audience. And by the way, if you're probably saying, well, only one person watches my Instagram live when I read a bedtime story, one is enough to qualify as the public. There is no definition for what qualifies as the public. The only thing is there are some cases that have defined the public to be someone that is outside of your inner circle. So if you broadcast on TikTok, and even if your mom watches it, but let's say some straggler rolls in and watches you, they're part of the public as well. So all that to say, just those are totally off limits. And I think that one little tidbit of information that might be helpful for anyone that is skeptical about this, let me just put it in perspective like this. If you worked on a copyrighted work and you decided to, publish it, you're going to take the leap, the jump of faith, you publish it, you make some money, royalties are good, your upfront costs for publishing the book are great, your back-end costs are looking good as well. You've put in so much time and effort in writing a book. How would you feel if someone then took your book that you spent so much time and effort and ripped it off by way of reading it out loud? You probably wouldn't be happy about that, right? And I think that that's the same scenario. You have to put yourself in the author's shoes. Now, by you reading this bedtime book out loud, author A is not getting royalty payments. They're not getting any sales out of that book because people are going to sit back and say, why do I need to buy the book? I just heard it. I heard it on YouTube. I heard it on Instagram. So I highly, highly discourage anyone from doing that kind of activity. Now, of course, There are certain bedtime stories that are well in the public domain, that are long expired. Let me put it this way: 1800s bedtime stories that originate from the 1800s are obviously going to be your safest bet for qualifying as public domain works. Anything that is in the early 1900s surely could be worthy of being part of the public domain. I would say anything from 1927 back is the kind of content that would qualify as the public domain. But of course, if you have any questions or any doubts about this whatsoever, please consult with a copyright lawyer so that they can give you the best guidance, because a lot of people may say, oh, the photos in here are black and white. It's definitely in the public domain. Honey, that ain't true, okay? That is not true. So do a little bit of research, go consult with a lawyer. They're going to be your best bet to give you the advice that you need.
And in a recent episode, we actually had a really great conversation where we talked about people wanting to read some of these older things that are in the public domain, but showing the pictures which have their own license and copyright that you have to be dealing with. So even if you find something that has multiple iterations out in the world and it is something that is in the public domain from the words, that doesn't mean the book itself is something that you can be reading and showing in your live streams, in your videos, in your public performances, etc. So make sure you check out that video. It is linked in the playlist, as well as a ton of other videos with Tony on the legal side of the publishing industry. And if you've got questions on the legal side of the publishing industry, go ahead and drop those down below, because we do this every single week to get your questions answered and keep you legally protected in this space. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at The IP Professor. You can check out my entertainment law podcast called End Scene. New episodes drop every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions down below, because Tony's coming back to keep us legally protected in the publishing space. And every single day, we're dropping brand new videos to help you navigate the world of publishing, from your writing to your publishing to your marketing, to make this your most profitable and most stress-free year ever. We'll see you in the upcoming episodes.